I would say, Vakasha, that the order by itself is promising, but this promise will need to be fulfilled through the actual report and the subsequent action which needs to be taken by the Supreme Court of India.
So I think the approach of the government to this question has been very, very cautious, and I don't see that caution waning anytime soon. I think it's a very real possibility that the fact-finding exercise could be stonewalled if the relevant authorities don't cooperate with the procedure.
We are quite possibly looking at a positive outcome, at least in terms of any kind of institutional acknowledgement of the Pegasus claims. So the acknowledgement of what has happened has at least been made first due to this order by the Supreme Court. And by itself, I think that the outcomes and the findings and the penalties and accountability which is placed will be seen at a much later point in time. So the court has gone through, and if you look at the structure of the judgment, it's quite fair. It first says what do the petitioners say, and then says what is the opportunity which has been provided to the union government. The union government has been provided multiple opportunities, as the order discloses, to place in forward a answer as to whether it procured Pegasus, how is it utilized, etc., etc. But only files what is called as a limited affidavit, and this is quoted within the judgment. The limited affidavit, as per the court's own words, is in quotes, vague and omnibus. So by itself, it does not state any clear answer and merely annexes a statement made by the Honorable Minister for Electronics and IT as well as Railways and Telecom, Mr. Ashwini Vaishnaw, on the floor of the House in Lok Sabha and the Rajya Sabha. Secondly, the court gets into the national security argument as well, which is cited by the government to prevent filing a much more detailed affidavit and getting into the factual instances raised by parties, especially those who have been impacted. This includes independent journalists. For instance, IFF was representing Rupesh Kumar Singh and Ipsha Sakti, who are independent journalists in Jharkhand, and their phones were actually surveilled by Pegasus. So in their petitions, they have made certain allegations, also how it impacts their sources. Even with respect to this, the court says that it will impact a individual's right not only to privacy, but also journalists for the respect to their freedom of speech and expression, their ability to do news gathering, and will cause a chilling effect. And then it juxtaposes the national security argument. And here the court is very, very clear. The court says in paragraph 49, national security cannot be the bugbear that the judiciary shies away from by virtue of its mere mentioning. Although this court should be circumspect in encroaching upon the domain of national security, no omnibus prohibition can be availed for against judicial review. End of quote. The court essentially is saying that if you're claiming national security and you're not providing details, you have to say which details you cannot provide. You have to give reasons for it. And hence, on the basis of the nature of the allegations raised, which are serious and the court observes are prima facie demonstrable as credible, the lack of any investigation by the government, and also the claim of national security not to provide any clear answers or factual submissions to the court goes on further and notes that it is constituting this committee.
I would say that the order is certainly a step in the right direction. I think the court has taken a good overview of the entire situation, and they've touched upon the most important points, which is the invasion of the right to privacy of the persons that have been targeted with this particular spyware. And that is what has kind of prodded the court on to actually do something concrete in this matter, as opposed to when these facts came up the last time around, these were kind of dismissed as, oh, you can't go ahead with the PIL based on news reports. So certainly the court has taken cognizance of the matter in all seriousness. And given that the court's powers of fact-finding as far as petitions under its writ jurisdictions, though, are somewhat limited, and this is also something that they note in their order, the court has seen value in appointing a committee to do this fact-finding exercise. So on this, on specific questions of fact, I think it's certainly, like I said, a step in the right direction to get to the heart of the matter and kind of resolve the concerns that have been raised by the petitioners. Certainly, the court has gone to great lengths in putting down in black and white what are the questions that the committee needs to be looking at and what are their powers to do so. And I think one specific point that comes up from the committee's terms of reference is that the committee has the power to take statements and call for records from any authority or individual. Now, on the face of it, saying any authority or individual does give them a very wide discretion to call upon public officials to produce documents as and when they may be required to find out, to get to the logical conclusion of this fact-finding exercise. However, given that one of the questions that the committee is looking into is whether or not the spyware was acquired by government agencies, I think there are certain provisions in our regulatory provisions that may I would say, restrain the ability of not just the committee, but also the court itself to look at the kind of documents that may or may not exist in this context. I've previously written about this, and the general financial rules, which is the omnibus regulation that governs public procurements that are conducted by civilian authorities in the country, have explicit provisions that empower the government to undertake certain procurements secretly, or basically not publish these procurements out in the open if they deem it fit in the interest of national security. Now, notwithstanding the fact that this is the first time that the phrase national security has entered the vocabulary of the general financial regulations, which in itself is a huge issue, I think if the answer to this question of whether the government acquired the spyware is in the affirmative, certainly there are certain documents that exist somewhere which have been marked as non-public or secret and are not fit for disclosure. Whether or not we like it, the kind of legal framework that we have is one that was framed by our colonizers to keep certain information completely out of the public domain. And our evidentiary rules kind of enable that kind of tendency. If we look at sections 123 and 124 of the Indian Evidence Act, which relate to official communications of the government or material that may have been disclosed to a public official in confidence, such material is explicitly prohibited from being produced in court as evidence unless the same public official who designated these documents as non-public agrees to their disclosure being in the larger public interest. So we may have gone through the process of going to the court and getting the right order, but I don't suppose that the word any authority or individual is going to be interpreted so widely that it exceeds the authority that courts themselves have in terms of what evidence they can and cannot asked to be produced before them.
However, as I said earlier, Gakasha, the proof is in the pudding. There is no clear direction in the order, and I think is one deficiency to be noted, that a copy of the report will also be examined by the court and then be made public. Hence, the report may just be submitted to the court, and the court and whatever steps it takes upon them will only then become public. So I would say that we lack clarity as to what will be the next steps after the committee does submit its report, what will be the accountability mechanism, as well as what will be the level of transparency. So independent commentators as well as victims who will approach the court may obtain a copy and also provide further inputs.
We are truthful, unafraid and independent because of you. Now you can help our reporting from the ground. Go to thequint.com, click Become a Member tab, choose a plan and pay. Because the truth is worth it.